Okay, today is July 1st. We're in summer. I can't even believe it. Today's subject is going to be talking about earnest money. So we're going to talk about the purpose of the earnest money, the consequences for the boxes that we check. We'll talk about seller damages. We'll talk about disputes for what happens if the earnest money needs to be refunded to somebody. I'll talk about what the interpleader action process is and how we can help our clients navigate through putting earnest money down. So what is earnest money? Well, earnest money is damages for the seller to retain in the event that the buyer breaches the contract. It shows that the buyer has an earnest interest in the property and lets them get a little bit of skin in the game, if you will. The amount of earnest money should show a buyer's commitment to the sale and their terms as well. And it should be a number high enough to make the buyer stop and think before they actually do decide to breach the contract. So when we think about this, let's think about the buyer's motivation. Is there enough, or is there much to think about for a buyer when they have a very small earnest money down? So say it's $1,000. Versus something like a larger deposit of, say, $20,000. You're going to find that buyers are more committed with the larger deposit down. Now, remember, buyers are protected in the contract by their contingencies. So if the buyer has no contingencies, the earnest money already belongs to the seller in the event the buyer cannot close. This also means a seller is going to have to wait to claim that earnest money until the buyer cannot close. So they can't necessarily get it early. If a buyer does have any contingencies at all, then that money is still protected for the buyer until those contingencies are waived. So we're going to be discussing the idea of how the earnest money plays a crucial part in the contract, as well as looking at contracts where earnest money is maybe immediately released to the seller as part of that negotiation tactic. Now, there are going to be times where there's going to be a disagreement on who gets the earnest money if this contract falls apart. Now, if this happens, there is a process for demanding that earnest money, and it's quite a laid out process. It's definitely something that is sequential. We do have it written in our contract as far as what happens next. So in the event the money cannot be dispersed, we do have a consequence for what happens next. Thinking about this question, if earnest money dispute ends up going to an interpleader, can the winning party recoup their legal costs? And the answer is yes. In Form 21, there is an attorney fee provision that states the prevailing party could recover the attorney fees and costs. So accordingly, the prevailing party is likely to get awarded their fees and other costs, but there are no guarantees of this. So moreover, if there's an award for the attorney fees, then there's not necessarily a reassurance that the fee will be of the equal amount they've actually paid. Long story short, when talking about a dispute with earnest money, a broker should never attempt to answer the questions on how the outcome will be. Instead, we need to be advising our clients to speak to an attorney on how they may end up in this process. So do we think much about it when we check the boxes on our purchase and sale agreement? We have line number 7, that is for us to put the earnest money down. And I know sometimes these boxes get checked off and these lines get filled in so quickly, we actually don't take the time to explain what some of the consequences are for checking or not checking these boxes. So do you explain to your client the purpose of earnest money or the consequences of having that much money on the line? How are we talking to them about this? Usually their first question to us is going to be, how much should I put down? Now, our answer may be requiring us to put on a seller hat for just a minute here. And in doing that, thinking about how the contract looks as a whole. We're going to think about our negotiation, our terms, what kind of contingencies we have, and what kind of closing time we have. All of the parts work together to make our offers more attractive. And remember that this is a default for a buyer's breach for seller's damages. Is the seller going to be off the market at a crucial time? Is it going to negatively affect the seller if they get taken off the market and then put back on the market? And if so, what exactly are the losses that seller is going to have? Think about how many days you need to go ahead and deposit that earnest money. This starts with a conversation with you and your buyer. You're going to need to know where the money is coming from. Is the buyer expecting to have a gift for this earnest money? Do they have cash ready to go? Are they going to be wiring funds? All of these things put together are going to kind of determine the timeline we should put in here. So keep in mind a couple things. If it's something like the buyer's writing a check, easy to drop it off, that can be a very quick turnaround time. But if your buyer is either expecting money to come in as a gift or planning on wiring funds, just the wire alone can take 24 hours to actually show up. And when it says earnest money is due on that date, that means the money has to be in escrow available by that date. So our Northwest, I'm sorry, did I skip over? I skipped over a couple things, actually. My apologies. Our Northwest MLS forms will give us both a definition and a consequence for the earnest money. So what I'm looking at right here is just Form 21, our purchase and sale agreement, and paragraph B in the long pages of the boilerplate language that sometimes get overlooked. Our Northwest MLS gives a consequence and definition for the earnest money in paragraph B. Now, if we are finding ourselves not using Northwest MLS forms, there's likely not going to be an earnest money provision that lays out what it means and what happens if things don't get negotiated. But with our forms, we're able to decide when and where the earnest money is going to be deposited in our contracts. Now, by default, the timeline to deliver earnest money is 2 days, and that is 2 business days when we're calculating this. So we as agents are not ever going to necessarily receive the money personally. We want to wait till escrow has had a chance to receive the completely, what they call the fully executed purchase and sale agreement, meaning it is mutual and signed around. Then what they're going to do is open up a file with all the clients' names and get this into their own escrow account, at which time they will provide instructions on how to get the earnest money to them. So we want to wait till that happens, because without that, we are holding on to a check when we're not supposed to be doing that, and this money has nowhere to go. Once that file has been opened, they're going to provide wiring instructions to the buyer if that's how the money is coming in. It is possible, like I said, for somebody to come drop by a payment, but the most common thing we're seeing right now, because it's just the easiest, is to do a wire. Now, the buyer does have a right, if they put a large down payment in their in their earnest money account over $10,000, to potentially get some some interest on that. And that's a discussion they can have at the time with escrow if they decide that that is something that works for them. But wiring seems to be the most common way to get the earnest money into escrow. So with that being said, it is going to be important that we have conversations with our buyer about earnest money fraud. We do have a pamphlet at our disposal, pamphlet P6, and it's just an important part of this client communication, making sure that we are protecting them and their money. You're going to want to make sure you also have a reference to your escrow officer's name and their phone number, and make sure this information is accurate. So many times this is going to be done after mutual acceptance or right at mutual acceptance. And just for that communication with your client, being able to make sure that they are providing the wiring instructions to the correct place. Now, earnest money is, I'm going to kind of skip through the whole purchase and sale process. Earnest money has been delivered to escrow. It's got there on time, and we've gone through our whole purchase and sale agreement. The next part of what I want to talk about has to do with what happens in the event of a termination or a dispute with earnest money. Now, earnest money is released from escrow for one of 2 reasons. One, the sale closes and the money is given back to the buyer for their closing costs. that buyer's money remains the buyer's money. Or two, there's a breach in the contract somewhere and the contract is terminated, and then the earnest money is going to be demanded to be given to one party or another. Now, this is the second part of paragraph B on Form 21, and this is where it explains what happens if the earnest money is disputed, if there's not a clear decision on who's going to get it, or even in the event that you have to terminate. This is the process that needs to take place. So I did record a class on terminations, so I'm not necessarily going to discuss how to terminate, but rather the process once you've done that. Once you've terminated the purchase and sale agreement, how do we talk about what happens after that? So one party terminates with a form, and you can pick the form. It could be in the 90 series, it could be because of financing, whatever. But one party, I'm going to just speak from the buyer side at the moment, the buyer will send a termination. And in doing that, if there's money in escrow already, there needs to be a demand for the disbursement of that money from escrow. So our forms actually do contain ways to make this happen. Now, our earnest money demand form is a Form 50. Our forms lay out, especially in this paragraph here, a step-by-step process for what happens after a contract is terminated in this boilerplate language. So by using the form, the buyer and seller are already acknowledging that if the earnest money is not dispersed within 20 days after the termination of the contract and the demand for earnest money is received, then escrow is required by law to send it to an interpleader. An interpleader action will take place, meaning escrow is going to release themselves of any of further conversations. They are not going to be holding the money anymore. A $750 fee will be paid to a court who will then decide the outcome of this earnest money. Now, they've already acknowledged this by signing Form 21. Like I said, escrow is required to follow the steps that are in the second half of this paragraph here. And basically, that's because all of our contracts to escrow are technically instructions on how to complete our transaction. So these Northwest MLS forms give escrow specific instructions to not hold this earnest money for more than 20 days. You are required to deliver a demand as soon as possible for that interpleader action. And in this, it does reference some RCWs. Those two RCWs are the fact that earnest money is required to be demanded by a party. And there is some interpleader verbiage for the second RCW that I don't go into detail for because I don't really have a way to interpret how the law writes some of these things. When making the demand, this Form 50 is considered a demand for disbursement for the earnest money. The Form 50 puts escrow on notice that there's been a demand. They will also have received the termination. So escrow receives this Form 50, and then will additionally, even if you already have, notify the other party that a demand for the earnest money has been made. So once escrow notifies that other party, that starts escrow's 20-day clock, of which this either gets decided or that money gets pushed off to a courtroom with a $750 interpleader fee being paid, and the courts get to decide what happens next. Now, if there is full agreement on what happens to this, buyer signs, seller signs, and escrow releases the funds as disbursed with the Form 50 instructions. If there is a difference of opinion, if a buyer turns in one that says all the money comes back to the buyer, it's all going to be in paragraph 1, that line that says to the buyer. And the seller says, you know what, I don't really agree. I think that you actually did violate your contract, and I'm not willing to give up that money. The seller can also send their own copy of a Form 50 with how they want the earnest money dispersed, because this is all about a communication to escrow. Buyer believes it's for buyer, seller believes it's for seller. Now, in the 20 days following the demand, the seller is free to market their home again and go back to active. The sale has technically terminated, thus the buyer has no more contract obligations to that seller. So you can actually be disputing earnest money while you're actively looking for another buyer. In fact, you should. As a seller's representative, your job is to get that seller a better offer as quickly as possible. Now, in the 20 days, we need to keep in mind that there are a couple of important things. We're going to have to document to our client that they should speak to a real estate attorney about potential outcomes of the dispute, and that we are not necessarily involved, but we're still kind of involved in this sort of client relationship. We do have outstanding documents that are in escrow. We have escrow companies that are still going to be contacting us about the communications that happen in here. If we receive information about this, if a buyer makes a demand and tries to keep sending proof of why they believe they should have the earnest money, we are still going to be communicating that to our client. And then, of course, showing them the information, asking them how they'd like to proceed. Sometimes there's going to be a very black and white outcome. You'll have something that specifically says, buyer terminated within their feasibility period and now is demanding the earnest money back. There's really not much to dispute in that. So it wouldn't be very advisable for our clients to take this to an interpleader if they're trying to argue about something that is very clear
At
in
the
the
Thompson's
contract.
office, this is Rhonda. How can I help you?
Hang on, Rhonda. Sorry, I can't
Hello?
mute Rhonda. So if there are decisions on how the earnest money gets dispersed that cannot be resolved in those 20 days, like I said, escrow is required to send this dispute to an interpleader. The fee starts at $750. Attorney fees are technically on top of that. So if this can't be taken care of by simply an interpleader, and attorneys need to be involved, and you're going to start racking up the bills at that point. The interpleader is taken out of the earnest money at first, but when it's awarded, the court may actually decide to give the full earnest money and additional fees. So the prevailing party would be the one who receives those fees that they've paid for. Losing party pays the fees. Now, there are a very few reasons why you'd ever want to write this earnest money disbursement on a Form 51. And it does happen actually quite a bit. There's a confusion between a Form 50 and a Form 51. So I wanted to bring this up because this is not an earnest money demand. A Form 51 is a rescission agreement, meaning it is an agreement between two parties to end a contract mutually when there's no contract out, and in doing so has predetermined where the earnest money is going to be divided, if divided at all. So why would somebody use a 51? I don't know. We don't want to necessarily mutually agree on something that one party actually doesn't have to get permission for. If there is a termination option, use the termination option. Don't ask for permission when you don't need it. There are usually conversations around earnest money if the Form 51 is being used for a rescission, and there are situations where maybe it happens to be beneficial for the seller to just let the buyer out. So this is not a form that's never used, but definitely do not use it if you're going to be demanding earnest money based on a termination. Do not sign a rescission if a buyer has a right to terminate. And sellers, do not sign the rescission if you want to have any conversation about this earnest money disbursement. Once you sign that rescission as it is, you're saying you're letting that buyer off the hook, and earnest money shall be dispersed as planned here. So here are some interesting situations. I am in a situation where the earnest money dispute is likely to go to an interpleader. I understand there are legal fees that are likely to be deducted from these funds. Do you have any idea how long the process will take and what the legal fees are likely to be? Also, if the buyer is awarded the earnest money, does the buyer have the right to sue the seller for the recovery of the legal fees. Straight from the legal hotline, the fees are likely to be deducted from the earnest money as the legal fees incurred by the holder of the earnest money, which is escrow, when the lawsuit is filed to initiate the interpleader action. So additionally, the court will take filing fees out of the interpleader fund as well. And if the buyer is successful, the court has the option of awarding the buyer a judgment that will include the full dollar amount of the earnest money, plus escrow company fees, plus court filing fees, plus lawyer fees, and whatever other costs are associated. So whatever happens is literally up to the court. We really don't have a good solid answer for anything like this. Another situation is I represent the buyers in a transaction. The transaction had a 45-day closing. The lender failed 6 days prior to closing due to information found in the employment verification done after appraisal. The purchase and sale contract included a financing contingency. The transaction had been canceled due to financing. So the firm turned in a Form 90I and the earnest money release, which is the Form 50, along with a lender letter that was all sent to title and the listing agent. The sellers are disputing the earnest money, complaining that they spent all the funds on moving trucks. The sellers are also saying that the sale fail was not their fault. So contractually, the buyers are protected to get the earnest money back. Is that going to happen? They had a financing contingency. And of course, as legal hotline always has it, legal counsel is advised. But beyond that, it appears that the seller's argument is without merit because the advising broker is trying to advise rights that are beyond their control, basically. And if the seller wants to insist on the earnest money, then they're going to have to talk to some sort of a counsel about this. Be careful with contingencies and be careful of how we're advising our clients. And with that, I want to talk about some safe words and some safe things we can say to our clients once we reach ourselves in a dispute with this, where we're not technically licensed to provide the outcome, although in our heads, a lot of us know what is and is not right. We just need to make sure that we're treading lightly when we talk to our clients about earnest money disputes. So here are some safe things to say. And remember, at the end of the day, we are not counseling them on this because we are not the decision makers. We're simply giving them information to sort of help them out. And remember that we ourselves are not actually lawyers. So with that being said, you could say things like, I've received that, thank you. Or the seller believes that your buyer is not entitled to the earnest money. At this time, we will not be signing the Form 50 as written. You can say the seller believes your buyer breached the contract and the earnest money should be awarded to the seller. Or to your seller directly, seller, I'd advise you to get an attorney to review this to see what your potential outcome would be if you were to argue the disbursement of the earnest money. And on the flip side, as buyers, the same thing applies with this. We've received communication. We want to acknowledge that because it's part of our duty as agents to keep material communication and deliver all of that. The buyer believes that your seller is not entitled to the earnest money, and at this time, we will not be signing the Form 50 as written. The buyer believes that their form number whatever, 22A, 35F, you pick it, whatever contingency is protecting them and is requesting / or demanding the earnest money be released back to them. Or buyer, I'd advise you to get an attorney to review this to see what your potential outcome would be if you decide to argue the disbursement of this earnest money. Now we are able to communicate facts, we're able to give opinions and ask our clients how they want to proceed. And at times, we can give the facts of the contracts as well if there is a breach, but still just need to remember that if these things go to court, a judge is going to decide. So we may be sure as sure can be on our end, but we still don't know what the outcome would be if a court were to look at this from the outside perspective. Sometimes we have no clue on what the outcome is going to be. there are options of using a promissory note as earnest money. So I wanted to touch on that really quick, just so we could think about what that actually means. And a promissory note is a separate contract to pay. I had to think about this, in a really odd way because I have to put things in a better perspective for me to completely understand how they work. But basically, what a promissory note is a promise to pay the earnest money at a later date. So there's no actual cash being transferred at the time this note is given. It's kind of like writing a check, but the check doesn't get cashed yet, or post-dating a check. At a breach, the buyer would be required to either make good on that note and pay the fees immediately or have a dispute, because the earnest money is still due no matter what, even if the earnest money itself has not been deposited into escrow. If there is a breach and there is earnest money noted, then the seller should be awarded that earnest money if the buyer did truly breach. Now, if the buyer were to get out on some sort of a contingency, then instead of having the earnest money refunded to buyer, the note would be just handed back to the buyer, and it would be like taking a check back that hasn't been cashed yet. So the payment would not be required anymore. There'd be no more obligation to make that payment. So picture the promissory note as kind of like a check. Like I said, the names of the parties have to be on it. The date has to be on it. I'm sorry if this is really small, but it writes out just like a check. So the buyer, the firm, the dollar amount, and then what you're going to check between lines 7 and 8 is the day that it becomes payable. So that's the day the money is actually due for this note. I'm going to hand you this piece of paper, and my due date for paying this piece of paper is this date. That's the date the money should be deposited into escrow. Now, you do need to make note that it is for earnest money. There is a buyer's failure to provide, to provide earnest money. This is going to work the same as a buyer paying directly to escrow. And the one thing I did want to note here is if you do use a promissory note, which I hope we don't, but if you do, all parties involved have to be signing on the buyer line. And if it is a corporation, it has to be signed as the corporation is written to the right-hand side, blah, 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 corporation by this person, noted that person's name and title. If you can avoid this, that would be best. It's just a promise to pay. And the idea behind the payment of earnest money is to make that buyer think twice about just backing out of something or breaching because of some other reason, you fill in the blank. So if you do find yourself needing to extend earnest money delivery, consider just extending the earnest money delivery due date, and not necessarily do it in a promissory note. These are kind of a dated, antiquated practice. They were originally used to get an offer accepted immediately and to show that, hey, this is earnest money, even though we don't have escrow open. And you really don't see them as much anymore for earnest money. So to kind of summarize, earnest money does serve several purposes. It will show your buyer their true interest in the property, gives the seller the picture of your buyer being serious, and it shows that your buyer has some skin in the game. Make sure that your earnest money deposit is high enough to give the seller a true remedy if they do breach. And we also need to make sure that our earnest money is enough to cover in the event of an interpleader. If you have a small earnest money deposit, it's really not worth either party fighting to go all the way through past your 20 days. So if you're going to put an earnest money deposit in to try to make it worth it, then make sure you're showing the skin in the game. Are we doing our clients a disservice by not advocating for a higher earnest money deposit when we represent a seller? Just thinking about that for our future. And I just want to leave you with a few of those thoughts as we have these conversations with the buyers and the sellers in the earnest money portion of our purchase and sale agreement. This section should never just be glanced over. there are pretty high consequences if we find ourselves in some sort of an argument over who should get this earnest money. And we're going to put the importance on this and getting our clients poised for their best potential outcome, whether you represent the buyer or the seller. Another side note to keep in mind too, if you have contingencies, and I said this at the beginning of this, but I'll just reiterate it again. If you have contingencies and your buyer wants to give the earnest money up, then you may want to consider waiving all of your contingencies, because at that point you may find yourself pulled between a buyer having the right to get out on their contingencies, but a seller who's already received earnest money and doesn't necessarily have it anymore or want to give it back. And the outcome of that is only bad for one person, and it is the agent who drafted that up. So I hope I've been able to share a little light on this, and I appreciate everybody listening. Thank you.